maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Please be seated. This Honorable House now resumes its sitting. Just before we get into the agenda and to do the call of the roll, I want this morning to advise as a speaker that on the last occasion when we met on Thursday this week, we did on Wednesday of this week, we did say that the House would be sitting for our next meeting on Tuesday the 9th. Notwithstanding that, I have been advised by the Minister of Transport and Mining that there is a matter of national urgency and importance which requires us to meet today, and I am so satisfied. And I am doing this in keeping with Standing Orders number 8, subsection 4, and I had sent a note to the clerk advising her of the situation yesterday, and I know she has notified members of the House. Hence, we have a sitting today. So, with that in mind, may we have the call of the roll.
Madam Speaker, just to clarify, and in Standing Order 8, paragraph 4 and 5, you said there was a notice.
Beg your pardon?
Standing Order 8, 4 and 5, you said there was a notice, you had issued a notice. To the clerk? To the clerk?
Yes.
Okay. No.
In keeping with the standing orders. Call of the roll.
Mrs. Holness, Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Mr. Montague, Mr. Shaw, Mr. Samuda, Ms. Grange, Mrs. Williams, Mrs. Malawu Fort, Dr. Tufton, Mr. McKenzie, Mr. Chuck, Mr. Vaz, Mr. Warmington, Mr. Hutchinson, Mr. Charles, Mr. Terry Long, Miss Smith, Mr. Main, Dr. Dunn, Mrs. Cuthbert Flynn, Mr. Morgan, Mr. Davis, Mr. Brown, Dr. Brown-Burke, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Miss Crawford, Miss Daly, Miss Davis, Mr. Golding, Mr. Graham, Mr. Green, Dr. Guy, Miss Hamilton, Miss Hannah, Mr. Henriquez, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Miss Lee, Mr. Miller, Mrs. Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Sibbles, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Wilson, Mr. Witter, Mr. Wright.
Statements by ministers, announcements, bills brought from the Senate, petitions, papers, reports from committees, notices of motions given orally.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move to introduce and have read a first time a bill shortly entitled the Road Traffic Amendment Act 2021. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to introduce the bill and have it read a first time, to move for its second reading and to take it through all its concluding stages.
Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House first obtained. Public business.
Madam Speaker, today we will be taking a bill shortly entitled the Road Traffic Amendment Act 2021, and this will be taken by the Minister of Transport. Thank you.
Madam Speaker, I now move for the suspension of the standing orders to enable me to introduce and have read a first time a bill shortly entitled the Road Traffic Amendment Act 2021, and to have it read a first time, to move for and take a second reading of the bill, and to take it through all its concluding stages.
The question, members, for the House is that the standing orders be suspended to enable the Minister to introduce a bill shortly entitled the Road Traffic Amendment Act 2021, to have it read a first time, to move and take second reading of the bill, and to take it through all its concluding stages. Those in favor? Aye. Those against? The ayes have it. Minister?
Thank you very much, Madam Speaker. Madam Speaker, the bill before you...
We have read, the clerk hasn't read, I'm sorry.
A bill shortly entitled the Road Traffic Amendment Act 2021, read a first time. No.
Madam Speaker, notice of a second reading. Madam Speaker, the bill before you, an act to amend the Road Traffic Act 2021, seeks to amend the Road Traffic Act. As such, this amendment is required to address the penalties in the Act. By way of background, Madam Speaker, Section 116 of the Road Traffic Act 1938 provides that the Minister may, by order, amend the appendix to make changes to fixed penalties. An injunction was granted by the Supreme Court restraining the government from imposing certain fixed penalties. This bill seeks to amend the Road Traffic Act to provide for updating of the fixed penalties. Madam Speaker, in relation to the Road Traffic Act 2018, which was passed but not yet brought into force, the reality is that the technical officers within the Ministry of Transport and Mining have been working assiduously on the changes to be made regarding the regulations, which, as you may be aware, are of an extremely technical nature. The Act and regulations will, however, be brought into force in short order, as they are at an extremely advanced stage, and I am the first to acknowledge the concerns of my colleagues in this House and the general public on this state of affairs. Madam Speaker, the bill today consists of only 2 clauses. Clause 1 of the bill sets out the short title and construction of the bill, and Clause 2 of the bill seeks to amend the 3rd schedule of the Principal Act by deleting the appendix thereto in order to increase the quantum of fixed penalties for offences under the Act. Madam Speaker, I therefore have this matter before the House and seeks for its consideration and passing of the bill. Thank you.
Can I, Miss? I'll get a different one. Thanks. Madam Speaker, we're here today on a Friday. It's on, I believe, yes. Madam Speaker, we're here today on a Friday to pass this short bill that's been brought by the government as a result of a ruling of the court granting an injunction preventing the, as I understand it, the imposition of the ticket fines at the levels which have been imposed since at least 2006. As I understand it, the case arose because a litigant has asserted 2 substantive points. Firstly, that the procedure for the imposition of the fines which have been in place on the face of it since 2006 was a procedure which was wrong in law, and that procedure was by way of an order made under the Provisional Collection of Tax Act, and secondly, that order had expired in 2007 because those orders are only of a temporary nature and last, I think, 6 months at a time, and had not been renewed since then. So in any way you look at it, whether it be that the procedure that had imposed the higher levels of fines at that time under the Provisional Collection of Tax Act was wrong, or in any event, the orders that sought to achieve that had expired long ago in 2007, and therefore there was no legal basis for the imposition of these higher fines. Of course, we are now 14 years later, and the quick fix that would have addressed that issue is now being brought to Parliament in a matter of days. And this could have been solved long ago. No doubt the technical people in the ministry had thought that the appropriate way of imposing these higher fines was by way of a provisional collection of tax order. That may not be correct. As I understand it, the court has not made a decision on that issue. But with consent, as I understand it, an injunction was granted prohibiting the imposition of the fines at the higher levels until the matter is resolved. So this fix is now being hurriedly brought on a Friday, a date which the standing orders doesn't allow the House to sit on unless a special permission is granted, which you've indicated you gave yesterday to the clerk in writing. And here we are seeking to pass this bill in a hurry. First of all, I would say it's It's extremely unsatisfactory that the Road Traffic Act 2018, which would have repealed and replaced the old Road Traffic Act from the 1930s, and which has in it modernized levels of fines, and which the government, when passing that legislation, said would be brought into effect within 3 months with regulations, is still not in effect, and those regulations are still not ready. Had that been done with the necessary expedition and diligence, we would not be here today dealing with this problem in this rather unorthodox way, where we're amending an act which is about to be repealed once a new act is brought into effect. I think it represents a dereliction on the part of the government in bringing the Road Traffic Act into effect. A lot of work has been done on that act. It didn't start in 2018. The legislation was brought to the House and went through an extensive process of review in the years leading up to that, from when we were in government. And for it to have not been brought into effect 3 years later, and we don't know when it will be, is just deplorable. When one looks at the bill itself, Madam Speaker, it purports to amend the third schedule of the Principal Act. But I think that's an error, because the third schedule is not where these ticketing fines are contained. The third schedule is created by Section 46 of the Act. The ticketing fines are in an appendix, which is created by Section 116 of the Principal Act. So Clause 2 of the bill is incorrect in seeking to amend the third schedule. It wrongly assumes that the appendix is part of the third schedule. It is not. The appendix is created by a completely different section of the Act, Section 116, and not by Section 46, which is where the third schedule is created. Another issue I have with the bill, and doing it this way, is that the substantive offences which are subject to ticketing fines, each of those offences is created by a section in the Road Traffic Act which imposes a maximum fine if the matter is dealt with in court, or if the section which creates the offence does not itself impose that fine. Section 108 of the Principal Act has a general penalty of $5,000, which is applicable to any offence under the Act where a fine is not specified. What we're doing here today will enshrine ticketable offences which are at levels which are substantially higher than the maximum fines that can be imposed if the matter were to be dealt with in court. Now, this is not normally how this should work, because the idea of a ticket is to create an incentive to have the matter addressed outside of court without burdening the court system with cases that can be handled through a revenue collection exercise, essentially, which is what a ticketing system is. This approach means that everybody who gets a ticket now will have an incentive not to pay it, but to go to court instead and either plead guilty and pay the maximum fine there, which is lower than the ticket, or if they feel they have a defense, plead not guilty and fight the case in court. It would be wise, I think, if we were going to amend the Act, an Act which we're about to repeal, indeed which has been repealed by the 2018 Act, but that Act is not yet in effect, so the repeal has not yet taken effect. If we're going to be amending an Act which is already the subject of legislation which has repealed it, then we should do it in a way that doesn't create a perverse incentive. And the perverse incentive is created by having the ticketing fines higher than the substantive fines in the sections which create the offences and which incentivize persons to go to court and pay their fines there through a court process which involves pleading, and either pleading guilty and paying the fine, or pleading not guilty and fighting the case, and it goes to trial and uses of court time, because the levels of the fines in the tickets are substantially higher than the maximum fines that can be imposed by the court if the matter goes to court. So Madam Speaker, the process we're going through here is really a bit of a mess. I think that the better thing to have done would have been to bring the 2018 Act into effect. We're now in 2021, nearly in 2022, and that Act would have resolved all these issues. I noticed that yesterday we never saw, Madam Speaker, your direction in writing, which is the sole basis upon which this is a properly convened meeting. Had you not issued that notice in writing to the clerk, this would not be a properly convened meeting, because under Standing Order 8, you can only have a sitting of the House other than on a Tuesday, Wednesday, or Thursday if a motion is passed to that effect. And we could not pass that motion today because this would not have been a validly convened meeting at which to pass the motion. So we never saw that direction that you issued, and I think it ought to have been circulated to members along with the notice of meeting yesterday, because what we're doing here is very unusual, and that is the proper route of authorizing this sitting to be properly convened. But the clerk, you have indicated it was done. I'm not doubting it was done. I'm just saying that, to my mind, it ought to have been more transparent in how it was done. And we should have had the direction that you gave to the clerk. Right, yes.
If I might, it says that I am to send the notice to the clerk, and the clerk will then. So I think we have indeed followed the procedure.
No, I'm saying we were never shown it. It was not circulated to members. I'm not saying the procedure was wrong.
The standing orders doesn't require.
No, but I'm saying
shown.
for transparency purposes, since we're being asked to sit on a Friday, the proper thing to have done when the notice of meeting was given would to be said this meeting is duly convened on a Friday because the clerk has issued a direction in accordance with Standing Order 108.4. Here it is. That's what I'm saying.
I heard you, but I had in members, please. The member has the right to express his views, and that's what he's doing. Yes. And I am saying as a speaker that I started the sitting of this House by indicating to all members of this House that I had followed the standing orders and I had directed it to the clerk, and the clerk on that had issued the requirement.
Yes,
so I did start that way.
No, you did, absolutely. Right. And the clerk nodded to confirm it as well. I'm just saying that given the peculiarities of what is taking place, I think from a transparency point of view, when the notice of meeting was circulated by email yesterday, a copy of your direction should have been attached to say this meeting has
Not
been...
should have...
Huh? Well, in my opinion, it should have been. I'm not saying the standing orders required it, but in my opinion, due transparency required it. Furthermore, Madam Speaker, the first notice that was circulated yesterday, the first notice of meeting that was circulated by Parliament yesterday, made reference to...
It is important that we recognize that each member, on their feet standing, has a right to speak. And so I'm going to ask you to allow the member to deliver his thing. We will all, this speaker will give us all the opportunity to respond.
Thank you, Madam Speaker. The notice that was submitted or circulated to members yesterday was one that said that there was a bill to be considered today called a bill shortly entitled the Road Traffic Amendment, Validation and Indemnity Act 2021. Now, that notice was given sometime in the course of yesterday. And subsequently, in the evening, after 7:00 p.m., another notice was circulated stating something different. It stated that the purpose of this meeting today was to consider a different bill, a bill shortly entitled the Road Traffic Amendment Act 2021. And that is the name of this bill here. This bill has no provisions in it seeking to validate or indemnify anyone for what has been done in the interregnum between when the higher fines were originally imposed and the correction of the matter now. Now, I don't know on what basis there was this shift. You know, in the morning, a notice was sent out saying a validation bill was to be taken today. In the evening, a notice was sent out saying that the bill was no longer a validation bill, it was just an amendment, and therefore wouldn't retroactively cure the problem from the government's perspective, but would seek to impose these fines at the higher rates going forward. We haven't had, the minister in opening never gave any explanation as to why, in the course of a day, yesterday, a fundamental change took place in the thinking of the government as to what was to be done today, what the legislation today would do. It just shows to me that government has been scurrying around in a rather confused way, trying to think about how to address this and calling us here on Friday to deal with this thing in a hurried manner. Yeah, no, I said that. Yeah. So that is probably why Section 2 makes reference to the third schedule of the Act, whereas what is being amended is the appendix. And the appendix is created by a completely different section to the third schedule of the Act because of the rush in which this is being done. We haven't even been given an explanation as to why this is being rushed. Haste make waste. I'd love to know why we couldn't have dealt with this on Tuesday, which was the next scheduled sitting of the House. So, Madam Speaker, we are here addressing a problem which has arisen, a problem which could have been solved over the last 14 to 15 years. The solution has been concocted within a matter of days, and legislation is now before the House in a matter of days. Indeed, the nature of the legislation seems to only have been resolved in the course of yesterday, because the notice that was given to us yesterday initially suggested that this was a validation and indemnity bill. And by the evening, that had fundamentally changed. The third schedule is not being amended. What is being amended is the appendix. And, Madam Speaker, I just think that this represents a really haphazard, chaka-chaka way of dealing with the matter. And Madam Speaker, it is not my role in this House to appease the sentiment It is not my role in this House to appease the sentiments of the government MPs. Our role is to point out where we think things have gone awry. Clearly, this is a rushed exercise to address an issue. No explanation has yet been given as to why we're here today, as opposed to next week, Tuesday, when the House had been adjourned to. What is the rush to deal with this on a Friday? Why is it that the notice that was originally given, suggesting that this was a validation and indemnity exercise, has changed and it's not a validation indemnity? What is the reason for that? We'd like to have an explanation as to that. And the clause 2 of the bill needs to be fixed because it is incorrect.
Member, we have heard you and you have made valid points. Yeah. I just want to, for clarity, because you have emphasized about the notice that was given. Please, members of the House, be advised that the first notice that was withdrawn, because there was an error, and the second notice sent dealt with the matter at hand. And the reason for the urgency, I did indicate at the beginning of Parliament that the minister felt that there was a need for us to deal with this matter today. And as the Speaker of this House, I would imagine that as the Minister seized of the facts and the situation relating to this has decided that there is some urgency. He has advised me, I've accepted it, and hence my notice to the...
Yes, Madam Speaker, I'm not suggesting that you second-guess the Minister when he tells you it's urgent, but he has opened the debate on this bill and he has given absolutely no reason as to why it's considered so urgent that we have to meet today to do it. No reason has been given. And I think that we are owed an explanation of that because it's a most irregular or unusual way of proceeding. Madam Speaker, those are my views on this bill, and I think other colleagues of mine have some other things to say about it. Thank you, Madam Speaker.
Madam Speaker, thank you. Madam Speaker, this bill that we have in front of us. Madam Speaker, can I speak from a seat other than my own?
Permission granted.
Thank you. Yes. Madam Speaker, you know, when I hear my colleagues on that side trying to force the opposition leader to stop talking, and many a times, Madam Speaker, whenever we are on that side and we are asked to validate something, a bill or act or some order that a minister would have made, sometimes we have seen it done a year, 2 years after, and it happens on both sides. I'm not trying to prescribe blame to the current government because this current order was given in a previous administration too. But as a parliament, Madam Speaker, I think that we need to look at when we are validating and try and get it right the first time so that we don't have to keep on coming back to the House. I think it has, as elected representatives, it's an injustice to the people who we represent. And I'm just saying that while the newer members on that side have to fall in line, just remember that we are representing others who have elected us and sent us to this House to do the right thing. All right? Madam Speaker, Madam Speaker, when we are asked to come to the House to pass a bill that, you know, I don't know about other members, that when I'm going to be contributing to a bill, to at least do some research, right? Because we're asked to pass a bill and we are seeing fines here, but I'm not, in this short period of time, able to at least to see what were the fees that were prescribed by the order of the then minister, to see if it is the same fees that are now being tabled here for us, or anything different for us to pass. So when the leader of the opposition asked why the rush, and I too, and I'm sure most Jamaicans would want to know why is it then that we couldn't wait until Tuesday. An order or a notice sent out that we are going to take this bill and carry it through all stages next week, Tuesday, that we are able to at least know if what we're passing here was what the order that the then Minister of Finance tabled in the House. So, Madam Speaker, also, I would have preferred that if we were coming here to pass any bill at all, would have been really the regulations from the 2018 Road Traffic Act. And I hear the Minister. But I feel that we are more saying to the Jamaican people that we are more concerned about revenue than we are concerned about the other aspect of road safety. that we have been in limbo for over 3 years, basically. And I don't see why it is, because what we're saying to the people of Jamaica is that we have an inefficient government and persons working within. And I'm sorry to say it. Because you have investors in that same act that we're sitting down, that has been in limbo, who have invested. We said that we want to start taking photos of license plate and ticketing persons for breaching road traffic acts. But yet still we can't do it because the law is not in effect. So, Madam Speaker, I came here today to say that we shouldn't send the signal that we did something wrong, but because of urgency of revenue and not looking at the other aspect of road safety, we are exceeding what we did last year in road fatalities. That should be an interest of all of us inside of this house too. It should be. So I would have preferred that we would have been giving as much urgency to the revenue side, that we are giving to the revenue side, that we give it to the other aspects of the Road Traffic Act. That has been in limbo. And I would love to know, Madam Speaker, if the Minister can tell us if the order that was tabled in 2006, that we are somewhat trying to validate these fees. No, but we are bringing the fees. What you're not doing is not validating it, but you're bringing it within the Road Traffic Act. But if these are the same, that was then the order made in 2006 by the then Minister of Finance, because you have asked us to come here to pass this. But I don't know if it is that you have increased this compared to what was being charged then by the order that was tabled by the then Minister. So if the Minister can address that, I'd be appreciate.
Madam Speaker, a few comments and a couple of questions. As was indicated by the member from Northwest Manchester, this bill is before us with great haste. We adjourned on Wednesday to convene on Tuesday. And as you have rightfully indicated, Madam Speaker, the standing order does make provision for exigencies to be addressed. And what I find very unfortunate and very discomforting is the response by a fellow member to bring clarity to what brought us here in the hurry that brought us here. When I saw the notice yesterday, I was really surprised because for all the time I've been here and all what the provisions in the standing order, we only meet on a Tuesday and a Wednesday, and in extraordinary circumstances like the ceremonial opening of Parliament, etc., we meet on a Thursday. But routinely, it's on a Tuesday and next on a Wednesday. And the standing order provides for normally only up to Thursday. So I was really surprised. What really is this urgent matter when we are scheduled to meet again on Tuesday? And as the Leader of Opposition mentioned, Madam Speaker, it would have been, and he prefaced his comments to say, it's not that the sitting is illegal or improper, because you clarified that at the very beginning. But given the very unusual nature of us being convened on a Friday, it would have been helpful, at least to me too, if in the notice it was indicated that in keeping with Standing Order Provision 8.4, the Parliament is being convened, and we will know something urgent. We just got a notice that the Parliament is convening. And that's all the member, the opposition leader was speaking to. And then there's a big jeer against that request that has been made. So I find that very unfortunate. Madam Speaker, Further to that point, the memorandum of objects and reasons in the bill states a decision has been taken to amend the Road Traffic Act in order to increase the quantum of fixed penalties for offences under the Act. This bill seeks to give effect to that decision. So the urgency is to increase the fees. The urgency of us being convened today is, as the bill says, to increase penalties. So the Parliament is hurriedly convened 3 days, 4 days ahead of the scheduled time to increase fees. That's why we are here, to increase fees. And why it strikes me, Madam Speaker, is against the background of many different urgent matters affecting the everyday lives of Jamaicans, for which the Parliament is not convened in a hurry. That is what struck me. I never knew really why it was convened, but when I came here and I read the memorandum of objects and reasons, it's the first I'm seeing written in black and white why we are here. And when I saw this, I said, oh my God, it is to increase some penalties. That's the urgency. The minister in his opening remarks humbly never used the word apology, but acknowledged the concern of members on both sides about the delay in promulgating the regulations of the Road Traffic Act pursuant to the 2018 Act that has been passed in this House. Madam Speaker, our being convened this morning on a Friday is very instructive of how we utilize the time and the technical competencies in the government. Because between 2018, the original bill was passed prior to 2016, when the government changed. Rightfully so, they sought to have further amendments to the bill, to the act then that was passed. No, the act, the report was finished. I don't remember if it was passed before 20. It was passed. It wasn't passed, right. And it is in their right. They have a new government. They want to use their majority to amend what was there, hopefully to make it better. No issue with that. But the Parliament went through the work from then up to 2018 and passed a new bill. And by the way, it came out of a joint select committee of Parliament. So it was a bipartisan approach in respect of the changes that the government seek to make from the previous work that was done in the previous administration. 2018. And now, 3 years later, the minister indicates the regulations are still outstanding. And why this one really hit home to me, Madam Speaker? Regulations for legislations require technical work. The Attorney General's chamber is very much involved. The Chief Parliamentary Council department is critical to these exercises, and other technical areas of government. But just recently, Madam Speaker, the committee of this House set up to consider making Portmore a 15th parish convened 14 times, utilizing the time and competence of those agencies. 14 times the Parliament was convened. What burned me, Madam Speaker, is how we utilize the resources of government. That is what really burned me, to use the term from the member from West Kingston. Yes, because we can do better. We can better utilize the resources available to us. I'm aware that the workload of the CPC, Chief Parliamentary Council's office, is huge. The AG's department There's a number of legislative things being pursued and want to be pursued. We did the Zozo review the other day. We do the Electricity Act. We're still continuing, and others which are being done. There's a huge demand, and especially the CPC is one of the most, I think, overburdened but indispensable agents of government. And we utilize those limited technical resources in other areas when matters like these, matters like the regulation that the minister made an apology about. They're lingering, can't be done. How do we best utilize the resources? The next point of concern for me, Madam Speaker, and I hope the minister can answer it for me. As the leader of opposition indicated, the first notice that we received indicated an indemnity act that we were seeking. And from my little bit of experience, an indemnity act here is to give legal effect to something that was done before, that was in breach or doesn't have the legal muscle or support behind it. So we want to indemnify an action or actions taken in the past. So that was my first thought. Of course, with limited bit of information about why we were here. As the member from Northwest Manchester indicated, we had very little time between last night and this morning to properly research and advise ourselves in terms of what is before us and what we are seeking to do. One of the things that jump out at me are the questions that I have that I would love the minister to answer. And yes, I have been following some of the coverage in the newspaper regarding that matter before the court that seemingly brought us here. I say seemingly since we have been formally advised that it is so. The fines that were imposed prior to that court action and prior to the passage of this bill, what I am construing is that those fines were over and above what the order provided for earlier on, and therefore there is no legal basis on which those were collected. That is what I'm surmising. If it is the case that those fines were collected from motorists without the legal provisions to do so, it means it would appear to me that if the fines were collected without the legal provisions so to do, they would therefore be collected illegally, because there's no legal provision for those. If the fines therefore were collected illegally, we can't use the power of the parliament to legitimize the extraction of funds from persons that were illegally collected. I believe that the only rational, reasonable thing to do is to, having recognized a failure, and administratively, legislatively, to make those fines legal, the only responsible and respectful and morally plausible thing to do is to arrange a refund to those persons of the difference between what the maximum fines provided for then as against what they pay now. And why do I say this, Madam Speaker? If we fail to do that, we are not implicitly, explicitly saying to Jamaicans, if you do something illegal, it's not all that bad, it can be made right. Because the government is doing that. The state is doing that. I know that underscore the state, because laws are laws not of the JLP or the PNP. Laws are laws of the state. It is the state that is saying this to the ordinary persons.
Madam Speaker, I rise on a point of order. Just to remind the member that there is a matter before the court. And so while I appreciate some concerns that are being raised, I would ask that you bear that in mind.
I note the comments by the Attorney General's chamber. But to making the point about the morality, the correctness, the fairness, the reasonableness. 3 years ago, coincidentally 2018, February 13th, 2018, the banking services bill was debated in this House and it was defeated. That bill sought to provide a minimum level of services for depositors, free of cost. The bill did not seek to regulate any fees. It didn't set any fee. It just prescribed a minimum level of service to say account holders, depositors can make these transactions within the bank against their own accounts, not against the bank's money, against their own accounts, not to be levied any penalty, which they call fee. When that bill was defeated, and I did some further research, I found out that the dormancy fee being charged by the banks was a breach of the existing Banking Services Act. Not while the bill that I tabled sought to explicitly prohibit the dormancy fee from being charged, the existing Banking Services Act that is in effect up to today, actually from 1960 to now, makes it illegal for the banks to charge the dormancy fee. Having done that further research and found that out, I announced that I was going to take out a lawsuit, which I'm still working on, a lawsuit against the banks for breaching the existing law. Within 2 weeks thereafter, Madam Speaker, all the banks, having consulted the law and recognized that it was in breach, all of them suspended the dormancy fee.
Member, as was said at the beginning of this session, it's a special thing, and I'm taking note of what the Attorney General said. And I'm just going to, because it's a Friday, it's a special sitting, all the speakers have said it, and I concur. But if I bring you to Section 35 of the Standing Orders, it does speak to the fact that when we are debating a bill or a motion, whatever you say must be relevant to that bill or motion, which is what the Attorney General alerted us to. So I appreciate, I am alerting as the Speaker to the Section 35 of the Standing Orders, and I'm going to read it. Subject to the provisions, debate upon any motion, bill, or amendment shall be read. You know, member, when the leader of the opposition was being disturbed, I clearly said he must be allowed to speak. I do believe that I'm allowed to speak now, and I'm saying with the greatest of respect to the Speaker, and I understand what the Speaker is saying, and it is valid. But I'm saying today, the bill before us, I'm just asking him to confine his comments towards it.
Very much.
I am saying that I'm asking him, and I am being absolutely fair and clear that I should be allowed to speak, and that I am saying, guided by the Standing Orders, number 35, he must confine what we're saying to the bill that is at hand. Thank you very much.
Thank you, Madam Speaker, and you are very correct. Very, very correct. Fully concur with that point you made. And my point is this. I was deliberate, perhaps too extensive, in laying the background to the point which I'm going to make. In 2018, when I announced that I was going to take out a lawsuit against the banks for the dormancy fee that they were charged, and they subsequently suspended it because it was in breach of the law. None of those banks have refunded what they have collected illegally to the depositors. That's the relevance to this point. Not one has refunded monies collected illegally, not provided for in law. It's against that background I asked the question about those penalties that were collected where there was not a legal basis or legal support. It was unjust, it was unfair for the banks to have extracted those dormancy fees illegally and have not returned it to the depositors in just the same way that to have collected some penalties that are way beyond what the law provides for. It is unjust, unfair, unreasonable, and I humbly request that the government seriously give consideration to what redress will be provided for to those persons from whom monies were illegally extracted by the fees that were paid at the time.
May it please you, Madam Speaker, I rise to make a contribution in this debate on the bill entitled An Act to Amend the Road Traffic Act. And I shall contain my contribution to a response to a point made by the Leader of the Opposition, who contends that Clause 2 of the bill is wrong and that the amendment being sought is an amendment to Section 116 of the Road Traffic Act. Madam Speaker, as the honourable member would know, that a bill is structured in a particular way, and the bill has clauses, and in fact the standing order refers to how the bill is to be printed, with clauses being numbered consecutively. And it also has schedules. An appendix does not stand on its own. Section 16 of the Road Traffic Act refers to the appendix. It provides in subsection 1 that the section applies to any offence created by and under an enactment and is punishable on summary conviction. B, being an offence specified in the appendix. The appendix in question is an appendix to the third schedule, and it is that which is being amended. So the Leader of the Opposition is wrong in contending that the bill is wrong in Clause 2 in not specifying the amendment being 1 to Section 116. The appendix in question is an appendix to the third schedule, and an appendix does not stand alone in relation to a bill. Bill is structured. May it please you, Madam Speaker.
Thank you, Madam Attorney General.
Madam Speaker, I wish to make a very short comment on the Act to Amend the Road Traffic Act presented. The speakers who have gone extensively on some legal and points over there, but nobody has in fact mentioned those who are responsible to implement this law. And this is why we are here today. The court case identified a lacuna in law, and by identifying it, created for the police a major problem, what I think was urgent enough to bring us here today. Road Traffic Act and the penalties attached is crucial to public order. And everyone in this room can appreciate, in fact, they spoke to it extensively, what is happening on the road today, and the need to ensure that the police can, in fact, carry out their duties effectively at all times. And even one day is a matter of urgency if we create that gap in there. And this law is not designed, there are a number of issues raised, will be discussed another time. It's designed to ensure that we can have the police continue their work on the road highways of Jamaica to seek to protect people's lives. That's what all this is about. And the principal reason why we are here today. And I think every single life in Jamaica is that important that we can call the sitting of the House to ensure that it's done. That is the urgency, Madam Speaker. So that's, Madam Speaker, my contribution, because the other issues we'll have opportunities to debate them at another time, I'm sure, and as we bring this. But this is critical to ensuring our police. the entire ticketing system, not yet complete, but already largely electronically designed. You'd have to go change software or do nothing. The police, in fact, were at quite at their wits' end as of Thursday night when they gathered this was on. They weren't even aware of the court case. And now when find that come Friday evening, they could do nothing on the road. It doesn't make sense, and we have to act as parliamentarians to correct that problem, provide the police with the requisite tool they need. And as the gentleman wondered off a bit in his presentation, the response, the member from St. Catherine, tells me that the concern for the requisite legal tools of the police is why they are where they are today. Because that's not been taken into consideration. And this is what this is all about. So, Madam Speaker, I thought it would be important to indicate to the public and to the members of my colleague in the House on both sides why we took time to come here today to ensure that the police officers who are already under stress can continue their duty on the roadway with some level of confidence. Thank you, Madam Speaker.
Madam Speaker, much has been said in this extraordinary sitting. There's one aspect of the sitting that I'd like to address, which is that as we look around, there are a number of members missing today. And on our side, I can tell you as the leader of opposition business on my side, I sought to, when I got the notice, I sought to inquire and to encourage as many persons to be here this morning as possible. Madam Speaker, a number of persons had just made other arrangements and could not. Please, if you shut up, you may know. And I want to say that given the extraordinary nature of this, those of us who have been in this House for some time have not, and even before us, have not seen this procedure being invoked. And therefore, I'm saying it's unfortunate because a number of persons would have wanted to be here. The notice was given overnight. They couldn't be here, and yet they are marked absent today. They are marked absent, and however small it is, there's a little remuneration that they would not get as well. Does the apology come after or before? After? Yeah. So, Madam Speaker, I was saying that in their absence, I've spoken to them and I know that there are some extenuating circumstances. So I think either they'll be allowed to do an apology after or some restoration be considered.
Thank you very much, House Leader, but I am here to tell you that notwithstanding what you have said, I have, as the Speaker, received excuses from several persons on both sides of the aisle why they are not here. So they have got the notice and they have sent their excuses in.
Madam Speaker, I actually was going to make a comment on the adjournment, but I just wish to use the opportunity to thank the members of the House who took the time to respond to the urgent call for a meeting of this honorable House today. And this includes the opposition. I want to also thank the technical team who worked beyond the call of duty to prepare what was necessary so we could meet today. I also want to thank those who took the time to send an excuse that they could not make it here today. And so I just want to end by saying we're all servants of the people. And being here today cannot be seen as being here today cannot be seen as a meeting that was not urgent or necessary, because the Minister of Transport indicated to you, Madam Speaker, that it was of some urgency, and you have responded appropriately, and we want to thank you as well.
Madam Speaker, I would like to thank the members who contributed to this debate. Largely, the debate, Madam Speaker, and as you're aware, deals with public order. And members of the opposition indicated about the whole matter of road safety, and I thank them for that observation. But, Madam Speaker, what struck me in this debate, and I would like to recommend that maybe we should be meeting more often on Fridays, because the level of energy in this debate, the participation from my colleagues on that side, when I look at them, Madam Speaker, I am happy. It has been a long time I have not seen the member from South St. Catherine on the front benches. It is a long time I have not seen the member from Northwest Manchester sitting so close to the member from Southeast St. Andrew. So I am happy for this. And as we came together today on a Friday, we are demonstrating both sides to the people of Jamaica that we are willing to do the work for their safety. Because it is not only the public servants who have to do the work. We who are elected as their servants are also doing the work. So I want to thank the members of the opposition and thank the members on this side and to thank the staff and the technocrats for facilitating this. And let this be a new day that as parliamentarians we can come together, we can pass laws in the best interest of the people of Jamaica. Madam Speaker, may I ask for second reading of the bill?
Members, the question before the House is that the bill...
Madam Speaker, just on a point of order, Madam Speaker. I asked some questions of the Minister of if the order that was tabled by the then Minister, if these fees, no, and the reason why I'm asking, because I'm looking at a comparison of the old Act and the fees that were in that Act, which is what the then Minister was updating, and looking at what is now brought in front of us. I'm sure that the increases of the then Minister wouldn't have been as significant as some of these that we're seeing here. And that is why, Madam Speaker, I said earlier that it would be good to know, because it can be like Nicodemus in the night trying to just bring through additional fees on the travelling public and those. And yes, I understand, Minister, that it is for public order, but we have laws out there that will that would aid the police in doing their jobs. What we are looking at here now are fees that comes with it when persons break the law, yes. Because when I look, Madam Speaker, in the act that these would have been brought from, the order would have brought from, exceeding the speed limit would have been $800. We're now saying $5,000. So as a member who is now being asked to pass this, as I have asked the Minister, it would be good for us to see if these are the fees that were passed by, because that is what my understanding is, that we are to bring that and wait until the new fees are brought when the new Road Traffic Act is being passed. So I want to be satisfied, Madam Speaker, in that order that was then tabled in 2006, is it the same fees that is in that order that we are now asked to pass in this bill?
Yes.
Well, I would love to see it. I'm not taking your word on that one right now.
Madam Speaker, perhaps I could be of some assistance to the member and bring his attention to the Provisional Collection of Taxes Road Traffic Order number 2, 2006. That's number 124A, dated Tuesday, December 12, 2006, and the Provisional Collection. And the Provisional Collection of Tax Road Traffic Order 2007, dated Wednesday, June 6, 2007, both signed by Omar Davies, Minister of Finance and Planning.
Madam Speaker, this is not an issue of who signed it or what. Okay, look, if it is that, no, but member, you asked me, you can beat up your gum all you want. You asked me to come here on a Friday. I left Manchester to come here. I want to be satisfied that what you have asked me. So don't come and tell me about it's the same thing without me satisfying myself. I have as all right inside here as you do. Yeah.
Yes, member, no, just before you do, remember, members, that once the bill is passed, we are going to go into committee stage after the second reading of the bill. Therefore, when we get into committee stage, all these things, we are at liberty to ask and go back and forth, because as a member said, he would like to be assured. But we are going to have an opportunity when we are in committee for all of that. Those in favor? Aye. Those against, the ayes have it. Madam Clerk.
A bill entitled An Act to Amend the Road Traffic Act, read a second time.
Members of the House, we will now resolve ourselves into a committee of the whole House to consider the bill clause by clause. Members, now we can clear up, all the things we would like to. I put clause 1. Those in favor? Aye. Those against? The ayes have it. I put clause 2.
Yeah, Madam Chairman, on clause 2, I just want the Attorney General to clarify.
Please allow the member.
Please clarify why she says that the appendix is part of the third schedule, or is an appendix to the third schedule. If you look at section 46(2) of the Principal Act, it makes reference to the third schedule in connection with vehicles that have excessive weight. There's no reference to the appendix in section 46. And indeed, if you look at the third schedule, you'll see that the marginal note to that makes reference to section 46. The appendix is mentioned in section 116, and specifically in more than one place, but in subsection 9, which was introduced by Act 21 of 1999, this particular part of it, and it says appendix, says that the fixed penalty for an offence specified in the appendix shall be the amount so specified in relation to each such offence. There's no reference to the third schedule whatsoever there. And the marginal note does suggest that the appendix was added by Act 21 of 1999. And if you look at the marginal note to the appendix, it makes reference indeed to section 116, which is where subsection 9 is. So I'm just not clear why we're saying that this appendix is part of the third schedule. On the face of it, it seems to be a separate part of the Act, which was introduced by an amendment in 1999, Act 21 of 1999, which introduced section 2 of that Act, introduced the appendix, and is referred to in Section 116, which is where the amendment was made in 1999. And Section 46 makes no reference to appendix whatsoever, but refers to the third schedule in the connection with vehicles that have excessive weight. Whereas if you look in this bill and the appendix, all of the offences have nothing to do with weight. No reflectors on the vehicle, no horn or other warning device, unlicensed motor vehicle, obscured registration plates, speeding, etc. Nothing to do with weight. So the appendix is dealing with a different issue to what Section 46 deals with and what the third schedule deals with. So that is why I think Clause 2 of the bill is incorrect. And what we're amending is the appendix. We're not amending the third schedule. Anyway, I know that I will not persuade the Attorney General to change her mind on that, but I just want to make that point because I stand by the point that I made.
Madam Chair, I can always be persuaded by reason. I would invite the member to look. An appendix does not stand on its own, and that is the point that has to be understood. And the appendix that is being amended is the appendix that is in the third schedule. So if he were to look at the Act itself and look at the third schedule, he would see the appendix there.
The appendix follows. There are 3 schedules to the Act.
Right.
And then there's an appendix.
Right.
And the appendix is and in fact,
no, there's an appendix in the third schedule. Look at the third schedule.
Yeah, I've looked at the
third schedule appendix.
The third schedule is followed by the appendix. Right. It's not an appendix to the third schedule. It's an appendix pursuant to Section 116.
An appendix does not stand on its own, member, as you know. It doesn't stand on its own. It doesn't stand on its own.
It is introduced by Section 116 of the Act.
It relates to the third schedule.
And to list the penalties and the offences to which those penalties apply. That's what it does.
The
anyway,
appendix doesn't
as I said, Madam Chairman, I stand by what I've said.
It doesn't stand on its own.
And I believe that we're erring in this, but, so be it.
You can confer with the learned CPC, who's quite competent, and it doesn't mean errors cannot be made. But in this regard, the appendix that is being amended is the one that is in relation to the third schedule.
And Madam Speaker, may I just say to the Leader of the Opposition, I had full discussion with the CPC, and she thinks what is in the bill is appropriate. Okay?
And I just beg to differ, as is my right.
As is your right. So I ask that you put Section 2, Madam Speaker.
I now put Clause 2.
Madam,
those in favour? Those against? The ayes have it.
Madam Speaker, you did defer questions to be answered to this section. I asked in my comments about what will obtain in respect to the penalties which were collected if the minister...
Not relevant at this time, Madam Speaker. Not relevant at this time, Madam Speaker.
It's very relevant, Madam Speaker, Madam Chairman. The question is, you may say you don't know what you plan to do, or you've made a decision not to refund it or to await the outcome of the case, but it's relevant because we are imposing higher fees by an amendment to the Act, and those fees were treated for many, many years as already in place. And the member is asking what is going to be done about those additional fees. Of course it's relevant.
Madam Speaker, if I may.
May I assist?
Just state my point a little bit more simple.
Member Jackson, may I assist?
Sure.
I do appreciate the relevance of your question. So not for one moment do you think it's irrelevant. I'm just asking that in light of the fact that we have a matter before the court and there are some live issues, that we not pursue that discussion at this stage.
Madam Speaker, in light of the plea made by the Attorney General, I will defer my answer to that question to a later date.
Thank you very much, member. I now put Clause 2. Those in favour, those against? The ayes have it. I now put the title and the enacting clause. Those in favour? Those against? The ayes have it. Members, I do report to the House the bill is having passed committee stage without amendments.
Madam Speaker, thank you very much. I ask that the bill be read a third time.
Question before the House is that the bill be read a third time. Those in favour? Those against? The ayes have it. Madam Clerk.
A bill entitled An Act to Amend the Road Traffic Act read a third time and passed.
Madam Speaker, there being no further business, I now move that this honourable House be adjourned. I just want to again, Madam Speaker, I just want to again thank everyone. Those who may feel it was not necessary to be here on a Friday, those who may feel it may not have been an urgent matter, and those of us who stand ready 24/7 to be here when we are called. Thanks to everyone. Madam Speaker, there being no further business, I now move that this honourable House be adjourned until Tuesday, November 9, 2021 at 2 p.m. Thank you so much.
Members, the question before the House is that the House do adjourn until next week, Tuesday, the 9th of November. And not just the date is important, the time at 2 p.m. Those in favour? Those against? The ayes have it. This House is now adjourned.